Hey guys, welcome to the think tank. Okay, just getting settled. Dogs are starting to huddle around me, getting ready to bark if I don't give them cookies. I've been under the weather lately, so I apologize. I haven't been streaming as much. But new documents have come out in the Richard Allen saga. Actually, we've been looking for some of them for the last probably hour or so that we're not able to find. But if they happen to be found before this live is over, we'll get to that too. So we'll just kind of touch on, let's see here. I want to look at a little bit that's been coming out. And it's just basically like, why is this happening? Jesus, Lord Murphy. So Richard Allen requests Indiana Supreme Court to remove the judge from his case and reinstate the defense attorneys. So what do you think the likelihood is of that actually happening? He's put on some weight. Must have stopped eating paper, which is good. So the man charged in the Delphi. Hello, Melissa. You are. The man charged in the Delphi double homicides has requested intervention from the Indiana Supreme Court to bring back his defense attorneys and remove the special judge appointed to the case. So, with that being said, do you think this is actually going to happen? Hi, Mel. Good to see you. Personally, I mean, we'll go through this and see what's truly going on, but, I can't see it. I can't see these lawyers getting back. I think the damage is done, and as far as she goes, I don't know enough about the law to know if she's done wrong. Some people say that this is just the way things go in this type of case. I've never seen this happen, but I'm not a lawyer, and I'm certainly not a judge. Okay, so one of Richard Allen's defense attorneys withdrew himself from the case before a hearing last month in Fort Wayne. She was in her own courtroom. That is the area she is originally from. And when the last judge recused himself, they brought in Fran Gull. So one of Richard's defense attorneys withdrew himself from the case before a hearing last month in Fort Wayne. The second defense attorney that filed a motion requesting Judge Fran Gull to be removed, saying that he was pressured to withdraw and that the move was not voluntary. Judge Gull claimed the disqualification was necessary due to gross negligence related to a leak of evidence. So this is basically what we're looking for right now. If I come across it later, after this, I will find it, because what we're looking for basically is the transcripts from this. I think they're about 200 pages. So I don't know. Do you guys think that they should be gone? Or do you think that Richard Allen does have a say as to who his lawyer is? These guys are now pro bono. They're not being placed by the court. What did Rozzy have against the media? I don't think he does he? Does he, Mel? Okay, so on October 27th, the court appointed Fort Wayne attorneys Robert Scremin and William Labrado to represent Richard Allen in a court briefing filed on Allen's behalf. He requested his original attorneys, Andrew Baldwin and Bradley Rozzy, be added back to his defense team. So there they are. And I mean, they might be good, but honestly, I have not heard great things about these 2. And one thing that we need in this case is good lawyers. We want it nice and clean, this, this trial. We don't need any kind of chance of them throwing it or mistrials. A new judge should also be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. A judge shall disqualify herself in any proceeding in which the judge's impartiality might be reasonably questioned, including circumstances the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of facts that are in dispute in the proceedings. Indiana Judicial Conduct Rule 2.11. The commentary to this canon provides that under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraph A 1 through 6 apply. His trial has now been set to begin in October 2024, having been delayed from its original January date. Let me see here, guys. Hello, hello. I heard when he left the courthouse, looked at a camera and said, "Media, get your facts right." Um, I think what he said was something along the lines of journalists, start doing your job. I believe that is what they said, but maybe it's something else. Maybe you're thinking of something else. The way now this came from, it didn't come from Rosie, it came from, oh my goodness gracious, Baldwin. And he said as he was leaving the court that, journalists start doing your job, which basically made me feel like there's something there and you guys dig, find it. That is kind of the way I took it, but I could be mistaken. Where are we here? It's quite the case. Like, it just took a hard left, didn't it? Okay. So we'll just look at a couple of these and then we'll look at the new documents. There's 2 out right now that I'm finding interesting. So again, talking about how Richard Allen is asking the Supreme Court to reinstate his defense team. Can you imagine? Like, I don't know. I've always thought this guy was guilty. And right now, with all of this stuff that's going on, I don't have a clue. I am so lost. So I'm thinking if that's the case, everybody must be a little bit thrown off by what's going on. It's gone from getting justice for Abby and Libby to watching Judge Gull's shite show happen. And these are my opinions, not a lawyer, not just my personal opinions, as always in the think tank. So again, it's saying that the attorneys for Delphi unaliving suspect Richard Allen are asking the Indiana Supreme Court to reverse a decision by Fran Gull, special judge in his unaliving case, to remove his defense team. I just don't know what to think of it. So on a hearing held on October 19th, Gull announced an unexpected turn of events and said defense attorneys Andrew Baldwin and Brad Rosie would be removed from the case. This decision follows evidence leaks from people connected to Allen's defense team. On October 27th, Gull appointed Robert Scremen and William S. Labrado to be Allen's new counsel in his criminal case. In a hearing that was held on October 31st, Gull officially, my bad. I just cooked myself right out of here. So she appointed Robert Scranum, William L. Labrado. Well, hello, Shauna. Good to see you, my friend. So now Allen is requesting that the Indiana Supreme Court to reinstate Baldwin and Rozzi as his defense counsel. He is also requesting his trial to be set within 70 days of the court acting upon his request. Allen is also asking the Indiana Supreme Court to remove Gull from the case to appoint a new special judge in her place. So what do you guys think? Is that something that they should do? I just think so. Let me look at those. Ooh la la. Sorry, guys. I'm just taking a peek at something here. No. Okay. I am back. Sorry, guys. Move this over here. So as a part of this filing, Allen is asking for a copy of the transcript of the meeting. Let me see what this is. Damn. Motion for transcript. I need the transcript. I got all excited there for a second. I thought we would have the transcript for a second there. I want to know what went on in that behind those doors. Mexi. Thank you. Hey there, Tony. How you doing, friend? We need the transcripts. So, let's see here. As part of the filing, Allen is asking for a copy of the transcript of the meeting. A, between Gull and the previous defense team. A, before the October 19th hearing. A. Hello, James. Was that enough Canadian for you, Tony? Oh, it's good to see all you guys. I'm a little under the weather. That's why I haven't been streaming, but a little bit, well, there's things we needed to talk about. So if I seem a little off, it's because I am. Why, thank you. Okay, so let's get back to this. So, as part of this filing, Allen is asked for a copy of the transcript of the meeting. Like I said, that's the transcript we want. Between Gull and his previous defense team before the October 19th hearing, where she announced that they would no longer be on Allen's case. Allen's team needs the transcript before an appellate court could rule on his requests. Unreal. Like I said, this is supposed to be all about these two girls. And look where it's going. It's just sideways. If we find out that this entire area is corrupt, I'm just throwing this out there. Like I say, I'm just throwing it out there. If it's not about them anymore, this is about possible corruption. And if there is corruption there, and we all know it's possible, What's going to happen to these girls and their case and these families? It's disgusting. It's disgusting. Okay, so let's see here. So if Alan's request was granted, that would place the beginning of his trial in January 2024, as was previously planned. However, in light of a new defense team being appointed for Allen, Gull moved his trial back to October and November of 2024. So, hypothetically, this guy's innocent. Hypothetically. What? Like, what the hell do you do with this? Personally, I think they need to scrap the bunch. Start from the very beginning. Get your crap together and charge this guy. What do you guys think? Mexi and I have talked about this quite often. What do you guys think about him having an ankle bracelet and house arrest? Would you guys be comfortable with that? Or do you think he should still be in the Huskow, like literally a prison off to himself? This transcript, I think, would explain a lot of what has happened, and I don't quite know who it's gonna look good for or if it's gonna look good for anybody. I think it's too far gone for any conviction. Yeah. It's ridiculous the amount of time it takes to get a perp to court. Isn't this something? It's unreal. So, what's it like there, James? Is it difficult like this is? Do you guys go through all this BS? Why not move to another prison in another state if needed? So, how do you feel then about him? I mean, how do you feel about him being locked up for 2 years before trial? I just don't know. I don't know what to make of this. You know, he's supposed to be, we're supposed to look at him as innocent, right? Makes a mockery of the judicial system. Well, it sure is looking bad for them there, isn't it? It's looking like a shite show because you need to be tried and contained in the state you are being accused of. Oh, this is it, Tony, right? Legally, he's innocent until they prove him guilty. So I would almost be good with house arrest. The thing is would he be safe? At least I think that's the answer. It's part of the amendments, so I figure that's why they would require the same state containment. Yeah, but what if he gets off? Like, what if he gets off then, Shauna? Shauna mama. Depends on the case, about 19 months on average in the UK, longer in complicated cases. I fell asleep last night. There's something on Netflix that they're doing, the cases out of Scotland. Is it always that green there? We need more pictures. It was beautiful, rolling hills. Yeah, right? I think so. I think it's looking scary and it's just sickening. Who you doing that for? For Shauna? It has to be something very happy. A happy drink. Alrighty. Yeah, it does. It literally makes me feel ill. Okay, let's see what we've got. Let's take a look at one of the documents. I was like the upside down margarita type. Okay, let's go over here. We'll look at the other one. So this is the motion. They've asked for the transcripts, and this is the state of Indiana on the relation of Richard Allen versus the Carroll Circuit County and the Honorable Francis C. Gull, Special Judge. So this is the motion for the transcript. Mexi, do you think that maybe they paid for that? Tranifesto, what's that? Hey, that's funny, Mexi, because my nickname for a good 15, 20 years was Bahama Mama. That's hilarious. Whoa, Mel, thank you so much, friend. Very appreciated. Very appreciated. Oh, you think they might have at least? Much appreciated. Let me get back here for you guys. All righty. Realtor by counsel respectfully requests that the honorable court order that the following transcript be prepared, the in-chambers proceeding held on October 19th, 2023, in support thereof. Realtor states the following. So that realtor is Richard Allen and the state of Indiana, the realtor, and these guys are the respondents. Realtor has filed this original action after the trial counsel attorneys Andrew Baldwin and Brad Rossi were moved from the case due to the court's belief that trial counsel engaged in gross negligence during the representation of Allen. Attorney Baldwin and Rossi requested the in-chambers proceedings be required, and undersigned counsel confirmed that the court reporter that there is indeed a recording of the proceedings held that day in chambers. 3, the Indiana the Indiana rules of procedure for original action require a realtor to provide the Supreme Court with a relevant transcript of any evidence in the record if it exists. 4, jazzy. Attorney Baldwin's and Rossi was disqualified as Allen's attorney at a hearing on October 31st, 2023. On November 1st, 2023, undersigned counsel contacted Jody Williams, the court reporter, by email to make arrangements for preparation of an expedited transcript. 5, court reporter Williams was out of the office that day, but promptly responded to client's email the next morning on November 2nd, 2023. Court reporter Williams informed counsel that the hearings held in open court on October 19th, 2023 and October 31st, 2023 could be prepared and made available by November 3rd, 2023. However, with respects to the in-chambers proceedings, court reporter Williams informed counsel that the in-camera meeting was a meeting of the parties and not a hearing in open court. It is confidential, and I am unable to provide that at this time. Sorry, guys, I need hydrating. I'm coming back. Much love, friend. Yes. It looks like it's in the case. Indiana has 2 volumes, but there's not a link to get it. Yeah, we're having troubles getting that. That's the problem. What if he's innocent? Keeping him in jail would be an injustice. I agree with that too, Tony, which is why the extra year for court seems dumb. Let him have who he wants and let's do this. Yes? Plus, he does have a right to a speedy trial. Did he waive that? I can't remember. Don't think so with Seagull at the helm. Seagull may be losing her law license soon. So do you guys think that it will be that serious? That those will be the repercussions? Oh, so then Judge Gull, speaking on 31st, says, I found findings in our hearing is just a crock of shite. So is the court reporter court or is the judge correct? Right? They can't make decisions like that. Like that almost seems like ganging up. It's like, what the actual? They need to go to superior court that has the power to do the job, I think. Take it to the upper next level. Agreed. It's very serious. These families, it's heartbreaking to think of these families. Becky and Mike Patty, the grandparents to Libby and her sister Kelsey. I mean, oh my God, my heart hurts for them. I've very briefly talked to Becky, just briefly, and same with Kelsey on Twitter, just brief stuff. But, just even that minimal contact, it just makes it that much more real and that much more heartbreaking. That's the thing. They're Facebook friends. And she's also with his wife. It's like, and they do things together. Good Lord. It's such a mess. All righty. So number 6, the undersigned counsel, Kara Wienick, responded that she would prepare her file and her limited appearance and written motion for transcripts as limited appearance counsel in the cause on behalf of Allen. Counsel informed the court reporter that attorney Wienick should be permitted to receive the transcript regardless of its confidential status. 7, after acknowledging that attorney Wienick's limited appearance and the motion for transcripts were on the docket, court reporter Williams informed counsel that she still maintained the in-chamber proceeding was confidential and thus she could not provide a transcript to counsel until the trial court granted the motion for transcript. I don't understand. It's like, what? 8, on the morning of November 3rd, 2023, undersigned counsel Mark Lehman traveled to Fort Wayne to obtain the transcript of the hearings being held in open court. Before attorney Lehman left Fort Wayne, attorney Wienick asked court reporter Williams if attorney Lehman should remain in Fort Wayne in the event the trial ruled on the motion for transcript. In response, court reporter Williams indicated that counsel could not obtain the transcript that day, even if the court permitted them to have it. What the hell? 9, as of the date of filing this motion, the trial court has not ruled on counsel's motion for transcript due to the emergent nature of this original action, counsel filed the record of proceeding without the transcript of the in-chambers proceeding, and now asks this court to order the transcript be prepared. Wherefore, Realtor by counsel respectively requests that this honorable court order that the in-chambers proceeding held on October 19th, 2023 be transcribed. So why are they having to fight for this? That just makes things look extremely sus. So I do believe that everything has been transcribed. And like I said, that is what we're looking for right now. And as soon as I can come up with those, I don't know, I might have to, I don't care if I have to buy them. I don't care. I want to get a hold of those. So if anybody sees that, get a hold of me on Discord. And like I say, I'll buy them, whatever it takes to get it. I think it's about 200 pages. But I would really like to know what happened behind those closed doors. The judge should not have interfered and let the defense put on their defense. Yeah. Yeah. But I mean, they're fighting it. They're fighting it. Attorney seeks new judge in Delphi case, citing bias against the defense. So is that what you think it is? Do you think there's some bias here? Are they disliking just the accused? Are they disliking? Is she just not liking those lawyers? Is she not liking? No. Mexi, you so rock. Boom. Boom. I knew she would. This woman doesn't give up. I tell you what. So you guys want to get into that? It'll just take a couple minutes here to get things set up. Oh, always. Is that what you're thinking, Tony? She just dislikes the strategy? I wondered about that too. Yeah. That's kind of the way I'm seeing it. Don't think she liked the Odin thing and bringing the person into it. Damn. Dun, 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 dun. That's pretty much when things started to go sideways, isn't it? Is when this Odinist stuff started to come out. And it just seemed right from there. Everything was just falling apart. Yeah, Mexi rocks. Mexi is on the case. It's taking its time loading. Whoop, whoop. All right. And like Flynn. Guys, it's huge. Yeah, Mexi rocks. If I had had a daughter, she would have been exactly like Mexi. She's even the right age. Okay. Okay. crazy. Let's do it. Let's do it. I don't know how your parents would feel about that. It'd be a win-win for me, but I don't know how your parents would feel about that. Mine. She's mine. I picked a spot in Canada for her to move. We were chit-chatting last night, and where would you pick? So I don't know if you guys have ever been, anyone's familiar with BC, British Columbia, the Okanagan. That's where I'd plant her. Just a beautiful, beautiful place. Okay, so this one's 41 pages. And what have we got going on over here? I think I best star these, right? $246. All right, so we'll go to the 41, right? Volume 1. So that's a lot of paperwork. Dun, 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 dun. Boom. Just like that. So this was filed yesterday at 9:35 a.m. Volume 1. Again, this is the state of Indiana. Realtor Richard Allen. Respondents, the Judge Circuit Court, the Honorable Francis Siegel. Wah, wah. Beach. And oh, here we go. Exhibit A. Oh, yeah, exactly, Shauna. Just the word volume. Uh-oh. No, I'm still going on the wrong one anyways. Who's the bibble? Come on. There we are. That's better. Let's do this. Okay, if you guys are in, I'm in. So what I'm going to do, I'm just going to make this bigger for you guys. I need to pull you over here. And let's put me down here. Is that a little better? Oh, right. Yeah, it's 20 to 12 here, noon. It's just about noon. Kettle's on. I think so, eh? Maybe that wasn't a cigarette, eh? Volume 1. Yeah. Oh, if you guys only knew what I was doing behind this scenes here. It's like, oh my God. Sitting here in my moo-moo having a chit-chat. Well, hello, Dandy. Good to see you, friend. We're just getting started. So we're going to go over the transcripts from the 19th of October. They finally transcribed it for us. And your place is looking beautiful, friend. I don't quite know how you know how to do all this stuff, though. You're amazing. Okay, so the volume 1 press release, chronological case summary, order of initial hearing, letter to the court from Allen, press release, protective order, emergency motion to modify safekeeping order, Indiana tort claim notice, and the Franks memorandum. Ooh, really? Verified motion for immediate transfer to custody, letter to the court from Attorney Rozzi, emails between trial court and counsel, verified notice of continuing representation, memorandum regarding possible disqualification or sanctions, motion to disqualify. Transcript of hearing held October 19th, 2023. Motion to reconsider. Okay, Prapes? Perhaps? Pripes? Pripe? I don't know that legal term. Defense counsel's appearance. Transcription of hearing held on October 31st, 2023. Affidavit from Mitchell Westerman. Affidavit from attorney Andrew Baldwin and Brad Rossi. Exhibit P. Okay, again, plaintiff, State of Indiana, County of Carroll versus defendant Richard Allen. Oh boy. Alrighty, let's see here. So, record of status hearing held on October 19th, 2023. Appearances for the state of Indiana. Nicholas C. McClelland, James Luttrell, Carroll County Prosecutor, and the Deputy Prosecutor with their address. Okay, so the Honorable Francis Siegel, Judge. Jody L. Williams, reporter. So the proceedings, the court, all right. We are on the record in the state of Indiana versus Richard Allen. Thank you for your patience, ladies and gentlemen. Thank you, Mr. McClelland, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I grant that oral motion to withdraw. And Mr. Rossi will be submitting a written motion to withdraw. I'm assuming within the next couple of days, they have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment, as Mr. Allen is now without counsel. I've ordered him transported back to the Department of Corrections. Mr. McClelland, I know that we've already scheduled a hearing in the Carroll Circuit Court for October 31st at 9 a.m. I'd like to maintain that hearing if we can, please. Attorney Nicholas McClelland, yes, Your Honor. The court, I think at that point we can have counsel appointed. I'd like to set a new trial date. Obviously, I don't believe counsel will be prepared within the next couple of months to try a case of this magnitude in January. So we'll set dates for the trial. I think we need to set a date as well for the suppression hearing that was filed now by former counsel. I have asked the attorneys to provide all of the discovery previously provided back to the state of Indiana. I know I entered a protective order on the discovery, and honestly, I don't remember when that was. I think it was in April of this year, perhaps. Maybe sooner, but the attorneys have been ordered to provide all of that discovery back to the state. And if you would maintain that until such time as it be returned over to the successor counsel, I would appreciate that, Mr. McClelland. Mr. McClelland, yes, Your Honor. The court, I've also asked the defense attorneys to cooperate with successor counsel. So right there, guys, let me just see here. Right there. I find that very, 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 very disturbing. If they are not good enough to run the case, then why are they there? Why are they able to train to get the defense attorneys ready for the case? If they're that negligent, then how is this okay? They're not required to do that, but I think I think that they will in the best interest of Mr. Allen. They're not required to provide any of their work product, but they will be required and have indicated that they will cooperate with successor counsel. So obviously, without counsel, Mr. Allen's hearing cannot proceed. I apologize that I know many of you have been waiting for several hours. I know, Mr. McClelland, that you and your staff and you had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control. Whatever. Oh, my word. But clearly, this is outside of our control. So, is there anything, Mr. McClelland, that you would like to state for the record? No, Your Honor. I think we could address the other issues at the October 31st court date. The court says, all right. With that being said, we are in recess. Thank you. I'll see you in October. Mr. McClelland says, thank you, Judge. And this concludes the status hearing had on October 19th, 2023 in that cause. All righty. This is probably the same date. State of Carroll County. State of Indiana is the plaintiff versus Richard Allen defendant. Certificate of reporter. I, Jody L. Williams, an official reporter for the Allen Supreme Court, Allen County, Indiana, do hereby certify that I transcribed from electronic reporting equipment all of the proceedings had at the status hearing held on October 19th, 2023 in said cause. I further certify that the above and foregoing transcript is a full, true, and complete copy of said proceedings. Witness my hand and seal the second day of November, 2023. Exhibit Q. So motion to reconsider comes now, counsel for Andrew J. Baldwin, and moves the court to reconsider the erroneous order of the clerk of Carroll County and the removal of appointed counsel with the opportunity to be heard. In support, counsel states. 1. In October 26, 2023, the court issued the following order. Clerk of the Carroll Circuit County order to remove Attorney Baldwin and Rozzi as attorneys of record in this cause. 2. The county clerk is an elected position duly elected by the people of the county. She or he is a member of the executive branch of the government, not the judicial branch. 3. Part of the clerk's responsibilities is to maintain a complete and accurate record of court filings. 4. No judge has the authority to oversee the clerk or order the clerk to alter the record of court filings. 5. A judge may order sealing of filings only if she complies with access to the court record rules, which Judge Gull has not. 6. On October 19th, 2023, Judge Gull obtained a coerced and involuntary oral motion of Mr. Baldwin that withdrawal is a nullity and invalid and not in compliance with Rules 3.8 and 7.0 of the Indiana Rules of Trial Procedure. Mr. Baldwin has never filed a written motion to withdraw and will not do so. By operation of trial rules, he remains counsel of record. They're really digging in their heels, eh? They don't want to move. They do not want to move. Hey, Angela, good to see you, friend. Welcome, welcome. Good Lord. So, 8. The Due Process Clause of the state and federal constitution applies to all citizens, not just the accused. The fundamental notion of due process is notice and the opportunity to be heard. 9. There have been no valid motions to withdraw by appointed counsel. There's been no order of disqualification. There is no legitimate basis for disqualification. See motion for recusal and to disqualify previously filed and incorporated herein by reference. 10. Upon the filing of the motion for recusal and to disqualify, the court loses the authority and jurisdiction to make rulings on other motions or issue orders other motions or issue orders other a hearing and ruling on the request for recusal and disqualification. 11. The court order to remove appointed counsel leaves the accused without representation, interferes with the attorney-client relationship, was done outside the presence of the accused, and prejudices his substantial right to the effective representation of counsel. Yeah, and there we are. Certificate of service, our signatures, information, Exhibit R. I object to the denied being denied. Good one, Mel. These guys talking tongue twisters. My tongue goes like, what? How you doing, Melissa? Good to see you. Really good to see you. Yeah. I think that they will in the best interest of their client. Yeah. So you do agree to some point that those two negligent attorneys have their client's best interest in mind, right? Yeah. It's true. Weird, 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 but so is Seagull. I need to have seagulls chirping in the back. Hello, hello. Yep. Yeah, I like that. I object to the denied being denied. He has changed quite a bit, hasn't he? He has changed quite a bit. He doesn't have that little goatee or whatever he had. His weight has really fluctuated, but I'm glad he's not eating paper anymore. I mean, doesn't seem to be anyways. He's put on some weight, and I don't know. I've never ate log. I didn't even sound good. He also changed a lot from his first stint in prison to him running over all those people. He did an interview with one of those TV specials, like Locked Up or something. Okay. Okay, well, Exhibit R, guys. What do we got going? Precipe? Hey, Charlotte. Good to see you. Welcome, welcome. Come on in. So comes now counsel for Andrew J. Baldwin and, okay, guys, I don't even know how to say this. Precipes for the recording and or transcripts of the 2 in-chamber sessions on October 19th, 2023. I don't know all the lawyer lingo. I don't know all that. Okay, so and or transcripts for the 2 in-chamber sessions on October 19th, 2023, or alternative. Oh my, you see, now it's going to start. Alternatively, to give counsel access to the recordings pursuant to the Access to Court Records Act. More specifically, Rule 3, definitions for purpose of this rule. A, court record means both case record and court administrative records. B, case record means any document, information, data, or other item created, collected, received, or maintained by a court agency, or clerk of court in connection with a particular case. Rule 2, who has access under this rule? All persons have access to court records as provided in this rule, except as provided in subsection B of this rule. Rule 4, general access rule. A, a court record is accessible to the public except as provided in Rule 5. D, a court may manage access to audio and video recordings of its proceedings to the extent appropriate to avoid substantial interference with the resources or normal operation of the court and to comply with Indiana Judicial Conduct Rule 2.17. This provision does not operate to deny to any person the right to access a court record under Rule 4A. Signed. Exhibit S. Wowza. Yeah, hydration. Yeah, he has changed a lot since he first came. But you guys, he looks better than he did for a while there. Like, do you remember this? I don't even know what that's all about. I really don't. It looks like shite. And I mean, for some reason, the lawyers allowed him to go like that. Yeah, more coffee, please. So, yeah. Okay, Exhibit S. Pro bono appearance form, criminal defendant. Boom. Nice. Yep. He stopped eating paper, I'm thinking. Unreal. Okay. Coffee down. Defendant Richard M. Allen. Defense attorney information as applicable for service. Lead attorney Baldwin. And the name Baldwin Perry Wiley PC and their information. Attorney Baldwin enters his appearance as Mr. Allen's privately contracted lawyer. Attorney Baldwin acknowledges his prior representation of Mr. Allen as his contracted public defender and reaffirms that he, Attorney Baldwin, did not and has not voluntarily withdrawn from Mr. Allen's case. He's in said capacity. The filing of this appearance is intended to convert Attorney Baldwin's status as Mr. Allen's public defender to Mr. Allen's private counsel, wherein Attorney Baldwin will move forward with said representation on a pro bono basis in the event that he is not reinstated as Mr. Allen's public defender. With well over 1,000 hours of time spent reviewing evidence, analyzing evidence, and preparing Mr. Allen's case for trial, and with the desire to have the court hear suppression evidence and the desire to get the case in front of a jury as soon as possible in order to honor Mr. Allen's 4th, 5th, and 6th Amendment rights. Attorney Baldwin enters his appearance. Will defendant accept fax service? Yes. And this is sent by Andrew Baldwin, signed, sealed. Wow. Okay, appearance pro bono. And again, it's giving Richard Allen's name, his case number. Attorney information, we've got Bradley and Broadly A. Oh, Bradley A. Rossi. Attorney Rossi enters his appearance as Mr. Allen's privately contracted lawyer. Attorney Rossi acknowledges his prior representation of Mr. Allen as his contracted public defender and reaffirms that he, Attorney Rossi, did not and has not voluntarily withdrawn from Mr. Allen's case in said capacity. The filing of his appearance is intended to convert Attorney Rossi's status as Mr. Allen's public defender to Mr. Allen's private counsel, wherein Attorney Rossi will move forward with said representation on a pro bono basis in the event Attorney Rossi is not reinstated as Mr. Allen's public defender, with hundreds of hours of time spent reviewing evidence, taking depositions, communicating with potential witnesses, and preparing Mr. Allen's case for trial, and with the desire to have the court hear suppression evidence and the desire to get his case in front of a jury as soon as possible in order to honor Mr. Allen's 4th, 5th, and 6th Amendment rights. Attorney Rossi confirms his appearance. Will accept. There we go. Rossi's signature. Certificate of service is information. They're not giving up. How y'all doing in there? Lovely to see you as well, friend. Pronounced Presepi. Presepi? Precip? Precipe? Precipe? Precipe. It means an order to request. Precipe. I got it. Damn. Thanks, Maxie. I appreciate you. So, record of hearing held on October 31st, 2023. State of Indiana, plaintiff versus Richard Allen, defendant, Carroll County Court. Nicholas McClelland, defendant, lawyers William Labrado and Robert Scremen. Do you think? I don't know about that yet. Okay, so the proceedings, the court, we are on record. Thank you, Karen. All right. Are we ready? Is the state ready? Attorney Nicholas McClelland, yes, Your Honor. Attorney James Luttrell, yes, Your Honor. The court, defense ready. William Labrado, yes. Bradley Rossi, yes. In court, we are on the record in state of Indiana versus Richard Allen. I'll show the state is here by Mr. McClelland, Mr. Luttrell. Defense is here by Mr. Labrado, Mr. Scremen, and I note yesterday late the written appearance by Mr. Rossi and Mr. Baldwin. So we are here. Mr. Labrado, earlier this morning, you filed a motion to continue the jury trial. That is correct, Your Honor. Go ahead, sir. I explained that to Mr. Allen. Okay. And what is the state's position? McClelland says, Judge, the state has no objection as long as the time is chargeable to the defendant. The court says, okay. Mr. Labrado, and Your Honor, this is our motion that we would accept all the CR for time. Credit for time? The court, yeah, I'll show in paragraph 4, the state doesn't object as long as CR4 is charged to the defendant. Okay, so then we have the appearances by Mr. Rossi and Mr. Baldwin. Gentlemen? Gentlemen, did you see her face when she went in? Oh, la, la, la. She looked furious. Alrighty, so attorney Andrew Baldwin, judge, where Mr. Allen has asked us to represent him, and we are. We entered our appearance to represent him. The court says, okay, well, as we had our hearing on the 19th, prior to that hearing, we had some discussions. Counsel, you withdrew. You chose to withdraw from the case rather than be removed for gross negligence. What changed in the 12 days? Mr. Rossi, well, Judge, I think I've made it abundantly clear in my pleadings with the court that the conduct of the tribunal in chambers a week and a half ago left us with no choice but to withdraw because we're going to put ourselves in direct conflict with our client by sitting in a courtroom and accepting, what a lashing essentially from your honor. And so that was a strategic move so as to protect our client's right. And I think I've made that abundantly clear. I don't know how that couldn't be clear at this point. Beyond that, us transitioning from contracted public defender to private counsel puts us in an entirely different situation with our client, which is the Sixth Amendment. His Sixth Amendment right to have representation, and to the extent that the court is trying to intervene into that right with some due process, it's my client's contention that that's just not appropriate and he has a right to have counsel of his choice. So I don't really know that there's much else to say. I think in a normal course of business, I'm a private practitioner. I was once a public defender in a normal course of business, and in every other case I've ever been involved in. When there's a public defender assigned to a case, such as Mr. Screamin and Mr. Labrato, excuse me if I messed your name up, but in any other case, when private counsel enters the appearance, the public defender taps out, and basically private counsel gets up and running. And I don't see why this case should be any different. Wow. Hey, Kiska, good to see you, friend. Hope you're having a wonderful day. It's kind of socked in here. It's on the plus side. It's +4, but we're socked in. And I've been getting like the migraines in the back, like my back. It's ignorant, but it happens a lot once this ceiling starts to get lower. So winters are a little bit brutal. So you'll probably find that, again, my hours are a little bit kind of mixed up as far as when I'm streaming. So I do apologize for that. I have to kind of work around this bloody thing. All righty. So let's see here. So the court. Well, again, you haven't answered my question that nothing has changed in 12 days since I found gross negligence on the part of the defense in representing Mr. Allen. Mr. Rossi. Well, the answer to that question is that we didn't act grossly negligent, and the court has an opinion that's different than our opinion. At this point, without some due process and some findings, with a notice, an opportunity to be heard, that we're just on a different page about how we acted and what our circumstances are. So that's the answer to the question. The court. Does the state have any options or wish to weigh in? So this disturbs me, guys. Why is the court asking for the state's opinion on whether or not the defense stays? Do you guys, what is that? Is that normal? Does the prosecution usually get to choose who their defense lawyers are? And so listen to this guy, Mr. McClellan. Judge, I guess I'm at a loss at this point. We've struggled up to this point, Judge, and again, I was there in chambers in the meeting. I agree with the statements made by the court about the defense being grossly negligent. See, where in open court does he get this opportunity? I don't understand. Again, this started back in our first hearing, back I believe November, with the actions outlined by the court about the defendant's statements in chambers. And then kind of a direct 180 from the statements went chambers once they left chambers. And there was a leak from the defense in December that wasn't made aware to the state or to the court until the state found out. Then we have various motions that were filed, and not only negligent statements, Judge, but I think outright lies. And I think that's been proven in court and hearings that we've had when we then have the Franks motion. So, what is happening in this courtroom? I have never seen such a thing where they get to speak out against their opposing lawyers. Like it's almost like this is slanderous, I guess is how it's kind of feeling to me. My opinion. My opinion. Have you guys seen this before? Where the judge asks the prosecution what they think about the current defense? Do you want these lawyers or would you like those lawyers? You just tell me, Mr. McClelland, and that's what we're gonna do. Anything else you'd like to say? Because, I think I agree with you. I think it's mortifying. Right, Shauna? So let's see here. Judge, that what you have outlined in a Frank's motion is very clear. The defense counsel spent over 100 pages outlining their theory of the case instead of arguments for the Franks. And again, I think everything they've done, including the most recent leak, is just an effort by them to push this case out into the public and try this in a public eye and not in this court. The state's concern is that Mr. Allen has a fair trial. That is the state's concern. But that goes both ways. We deserve a fair trial too, Judge. That right goes both ways. And I just don't think the actions by the defense can be attributable to anything other than gross negligence, Judge. So that is the state's opinion. Oh, it just seems so wrong to me. Like, what, she's not smart enough to figure this out for herself? She doesn't what, does she not know the laws? Why would she do this? It's adding fuel to the fire, in my personal opinion. Just my personal opinion. I don't like the way she runs her courtroom. But again, I am not educated in the laws of any state, let alone getting into the higher courts. I know nothing about them. And again, state to state, it's different. I just have never seen such a thing. So, is this all going to blow up as well? Yeah, and vice versa. Is this going to blow up as well? Why that's showing distaste towards the other counsel. Like, I don't know what I think of any of this. I don't know. So, court, Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rossi represent you in this matter. I have grave concerns, Mr. Allen, about their representation of you. My previous findings of this court of their gross negligence. Mr. Allen, you're entitled to adequate representation in your case. You're entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know you've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had, with the gross negligence that I have found. I can't do it, sir. I just can't. I have, and then Mr. Baldwin is like, Judge, and Judge says, just let me finish. I cannot allow that. I have appointed able counsel to represent you. Actually, I play Scrabble with them, so I know they're good lawyers. Good God. That's just me. I've appointed able counsel to represent you. One of these guys actually was saying how guilty they thought he was at one point, if I remember correctly. Yeah, she sure did, didn't she? She lawyered right up dandy. And for whatever reason, um, oh my goodness, they who was it that refused to even, oh my god. I mean, she can't get lawyers. They turned her down. Scrabble, can you spell unfair? Right? Okay, so let's see here. They have an investigator here as well. Mr. Screnham is here. Mr. Librato is here. They have an investigator here as well. And I will grant their motion to continue your trial. But I am sorry that this is happening to you, Mr. Allen. Mr. Librato, Mr. Scremin, I know you have not talked with the state. I know you have not yet received discovery. There is no way that you can tell me that you will be ready for trial. I've asked for, again, I have asked former co-counsel to cooperate. I have asked former counsel to provide discovery for you. It is my understanding that Mr. McClelland, you've indicated that this has not been provided to you. So I'm still not understanding, guys. So it's my understanding that Mr. McClelland, you've indicated that this has not been provided to you. He says, correct, Your Honor. The court, gentlemen, when can I expect that you would return the discovery to the state of Indiana? Baldwin said, by the end of the week, perhaps today. The court, that would be great. If you could get it today, that would be wonderful. Then that can be provided to successor counsel. You're not required to cooperate with successor counsel. I would hope that you would in Mr. Allen's best interest, but that's entirely up to you. I know if you could have the discovery to the state by the end of this week, that would be great. I know that I'd previously entered an order that discovery was to be completed by November 1st. Obviously, that's not going to happen. Do you want to pick a trial date, Mr. Librato, Mr. Scremin? And they say yes, Your Honor. Briefly speaking with the state, tentatively, we would like a trial date in November, but not knowing what exactly we're going to be getting. I can't tell the court with any certainty that we would be ready in November. We will do everything in our power to be ready by then, but it's my understanding that it's a massive amount of discovery. The court, is it Karen? I know that you brought the calendar in. Could we get a date in November? I'm looking at November 24, 2024. There's an election day, there's Veterans Day, and Thanksgiving. Mr. Librato, if October or December would work better. So they figured out October. Mr. McClelland, that's fine, Judge. The state, whenever, is fine with the court, is fine with the state. Sounds like a little bit of a butt kisser. The court, Mr. Scremin, Mr. Librato. Attorney Robert Screnham. October would be fine, Your Honor, for a start. Okay, then why don't we look at October 14th? It's marked off. What is that? Columbus Day, Your Honor. Okay, that doesn't work out. So we'll look at the 15th to the 31st. The court says again, we will, and we again would pick the jury in Fort Wayne and bring them here to Carroll County for the trial. There's a pending motion to suppress. There's a Frank's motion that is not yet. I haven't finished even reading it. Oh, come on. Okay, I haven't finished reading it or going through all of the hours of interviews that were provided on a flash drive. So you need a hearing date for that. Once you get the discovery and once you've had the opportunity to review the pleadings, you could either adopt those pleadings or make your own. It's up to you. Anything else from the state? Baldwin. We want to create a record to be clear on what you're doing. You're disqualifying Brad and me. Is that correct? The court said correct. Mr. Baldwin, we would like to be heard through my attorney, Hennessy. She said, sure. So, Attorney David Hennessy, good morning, Your Honor. I do have a limited appearance on record, which hasn't been removed or disqualified. The court has my preliminary memorandum about disqualification when Mr. Rossi and Mr. Baldwin were appointed counsel. This is yet different. The law that I gave the court is even more certain. The court appears to be saying that it's protecting Mr. Allen, but the court's finding of gross negligence was summary, without notice, without opportunity to be heard. Had you given Mr. Rossi and Mr. Baldwin notice of your intentions on October 19th when they were formed, which seems to be like a week earlier, then they would have been prepared. I can tell you this on behalf of both of these gentlemen. You would have the Indiana Public Defender Council come testify. You would have competent attorneys from across the state come testify. You would have defense counsel that have been declared experts in criminal defense. Mr. Baldwin's one of a handful of lawyers in the state that's certified in criminal defense. So your summary ruling violates the Constitution, and summary ruling is unfair to everyone, especially Mr. Allen, because he was never able to make a record. Your finding of gross negligence, what you cited to them in chambers, which was never put on record, is not gross negligence. It's a zealous representation, maybe too zealous for the court's favor, but it was good lawyering. The memorandum on the Franks issue is a work of art. It's legal writing at its best. The court, this has nothing to do with the Franks issue, sir. Mr. Hennessy, no, but that. The court, nothing to do with that, so please stay. No, it has to do with your finding of gross negligence, and what I'm citing to the court are the activities. I never mentioned the Franks. Mr. Hennessy said, I'm sorry. And the court said, never mention the Franks hearing? Never mention the motion, sir? Mr. Hennessy, okay, you mentioned the transport orders, unfortunately, and public, and I was not allowed in representing Mr. Baldwin. And unfortunately, the public and I aren't privy to the recordings of the session outside of the presence of Mr. Allen. He has a right to be present at every critical stage of the proceedings. When the court coerces a withdrawal or quitting, that's a critical stage of the proceedings. He wasn't present. And I'd be happy to address each and every point that you think constitutes gross negligence. I've practiced criminal defense for 40 years. I understand and know in detail what these two lawyers have done on behalf of Mr. Allen. Has been nothing but zealous representation. So thank you. I have no expectations you'll change your mind for allowing us to make a more complete record about your findings of gross negligence in disregard for Mr. Allen, and unfairness to Mr. Baldwin, and unfairness to Mr. Rossi. The court thanks him, and he thanks the judge. Anything else from the state? McClellan said no. The court asked Mr. Screamin and Mr. Librato. Everybody said no. All right, thank you very much. We've set a trial. Brutal. This concludes the proceedings at hearing on October 31st, 2023 in this cause. Wah, guys, wah. How y'all doing over there? So if he's found guilty, they can go back and say his counsel didn't do a good job because they got replaced. Yeah. I mean, it's turned upside down. Mustard, mayo, and radish? roast beast, grilled cheese, horseradish, lunchtime. Nice. Nice. You guys. The firm stance of the lawyers really make me wonder, why would they put all their reputation and their livelihoods for this person? That's what I think, Shauna, like, they are really putting their names on the line, their businesses. It's just, oh my God. Do they truly believe in him, or do they just really care about what happens with him? Do they believe he's innocent? It's just the way it's going, it's brutal. It's brutal. So don't forget, before we even got to Siegel, we had the other judge that recused himself. He said he was uncomfortable, he was scared, that the media was just they were acting scary to him. He quit. Before McClelland, there was another prosecutor. He left. So what is going on that everybody is leaving? They want this judge gone. I mean, I don't know the laws. I don't know how all this stuff works, but she doesn't seem ethical to me. If I just think about ethical people, she doesn't seem very ethical. Mm. Oh, sorry, hydrating, guys. Ooh la la la. Oh, are you kidding me? Shauna, are you serious? I'm coming for a visit, friend. Okay. So we're on page 32 of 41, guys. We're getting there. And that other document was 200 some. What do you guys think of going through the documents? Is it a bit much, or are you happy with the information? Or is it just not so much? Oh, they are. Yeah, 1000%, Mel. I couldn't agree more. It's been a shite show. And yeah, it breaks my heart for the families. Like, literally, once it makes me feel like vomiting. Abby was an only child. Is this a snapping turtle? Okay, so State of Indiana versus Richard Allen, Certificate of Reporter. Jody L. Williams, an official reporter for the Allen Superior Court, Allen, Indiana, do hereby certify that I took transcribed from electronic reporting equipment all the proceedings had and held on October 31st, 2023 in said cause. I further certify that the above and foregoing transcript is full, true, and complete copy of said proceedings on the second day of November 2023. Exhibit U. Okay. Affidavit comes now. Mitchell Westerman. You guys want to remember this name? Being first duly sworn under oath, and states that the following information is within his personal knowledge and is true to the best of his knowledge. 1. I was attorney Andrew Baldwin's building, waiting to visit with Andrew. He was in his office, either meeting with a client or a telephone call with the door closed. I went into the conference room to wait. I observed printed copies of photo evidence on the conference room table. I took pictures of a few of them. Andrew Baldwin did not give me permission to take the photos of the printed copies. He was not present and he did not have any knowledge that I took pictures of the evidence photos. I am freely and voluntarily typing and signing this affidavit on my own accord because it is the truth, sworn on the 18th day of October. So, this is the guy that caused all of the crap, guys. This is the one that went in and took photos of deceased little girls. We can't forget this. Abby and Libby, he took pictures of their unalived bodies and passed it on, made them public. The fellow he passed them on to, he unalived himself. This man, in my personal opinion, is a maggot. He is a POS. Mitchell Westerman stated and states that he went into a closed up room, noticed pictures on a conference room table, and started taking pictures of them. This is supposed to be a friend. Can you imagine? This is supposed to be his friend. Piece of shite. Piece of shite, guys. Affidavit. Attorneys Bradley A. Rossi and Andrew Baldwin being duly sworn upon their oath, swear and affirm to the following. So that guy, I haven't heard of charges yet, but he's exactly as you say, deuce canoe. Great big deuce canoe. So number one, is Tracy in there? Hey, Tracy. Good to see you, friend. So Attorney Baldwin is one of only 4 Indiana attorneys certified as criminal trial specialists by the National Board of Trial Advocacy as authorized under Indiana Rule of Professional Conduct 7.4. Attorney Baldwin has represented thousands of clients all over the state of Indiana during his career, which has spanned nearly 30 years. Many of these clients have been accused of all sorts of really bad crimes, guys. Additionally, he estimates he has represented clients in more than 125 jury trials over the course of his career. On multiple occasions, Attorney Baldwin has been asked to teach trial techniques to lawyers, young and old, at the Indiana Public Defender Council's annual week-long trial practice institute. I didn't realize that he had all of this behind him, versus the ones that they are trying to get in, her Facebook pals. Brutal. It's just gone south. Okay, so, let's see here, 125. In the past 2.5 years alone, Attorney Baldwin has represented at least 5 clients charged with M. Attorney Baldwin has never been disciplined in any way as a lawyer during his nearly 30-year career. This guy, look what he's done to his friend. Attorney Baldwin. Okay, Attorney Rossi has a BS in criminal justice and an MS in criminology and is previously employed by the Indiana Department of Corrections, Marion County Pre-Trial Service Agency, and also worked as a private investigator, investigating both criminal and civil matters before obtaining his law degree. Attorney Rozzi has over 20 years of criminal trial experience, handling thousands of cases, including 8 cases, 3 of which have been tried to juries. Attorney Rozzi has also tried various other major felony cases, including and not limited to cases involving really gross, ignorant things. Attorney Rozzi was previously certified to handle DP cases. Good catch, Mel. I just looked over. Okay, how long have you been doing this? You guys are doing good. Alrighty, so Attorney Rozzi practices regularly in Carroll County, where these crimes occurred, and in surrounding counties, is very familiar with the geographic area near which these crimes were committed. Attorney Rozzi is the designated Cass County representative for character and fitness interviews associated with newly sworn attorneys. This appointment came by way of recommendation from the Honorable Judge Lisa Swam, Cass County Superior Court 2. Attorney Rozzi has never been disciplined in any way as a lawyer during his 20-plus year career. Richard Allen desires Attorney Baldwin and Attorney Rozzi continue to represent to see this matter to its conclusion. Richard Allen has asserted this in writing and orally in open court as recently as October 31st, 2023. On August 17th, 2023, Max Baker and Attorney Rozzi visited Richard Allen at the Westville Correctional Facility. During that visit, Attorney Rozzi tendered a motion for early trial to the client, Richard Allen. Attorney Rozzi further explained to Richard Allen the desire of his attorney to use the motion to firm up the January 8th, 2024 jury trial setting by filing the motion sometime during the early portion of November 2023. Richard Allen signed the motion, and Attorney Rozzi maintained the original motion undated in his specific and continues to possess the signed motion. Wow. October 4th, 2023, Prosecutor McClelland, Attorney Baldwin, Judge Gull, and Attorney Rozzi participated in a phone conference regarding motions requests that were filed by Defendant Allen on or about October 2nd, 2023, including defendant's motion for discovery deadline. During this phone conference, Judge Gull commented that she assumed the defense's request for discovery deadline was intended to support a request to continue the January 2024 trial date. Attorney Baldwin then communicated to Judge Gull and Prosecutor McClelland that the defense was not interested in continuance and, in fact, intended on going to trial on January 8th, 2024. The parties participated in a telephone conference with the court on October 10th, 2023, to discuss the matter of Westerman surreptitiously taking photos of crime scene photos, what a frickin' pig, and deposition exhibits prepared by the defense. During this phone conversation, the state suggested that the disqualification of the defense counsel might be appropriate. In response, during the same phone call, Judge Gull then indicated to the parties that she was leaning towards disqualification, but mentioned no rationale for her comments. What the hell? Motion for early trial. Again, the state of Indiana versus Richard M. Allen. The defendant, Richard M. Allen, by counsel, moves the court for an early trial within 70 days, pursuant to the criminal rule 4B1 in Indiana Rules of Procedure. Richard Allen, Brad, he needs to eat. Look at how rickety he looks. The verification of accuracy. I verify under penalty of perjury that the documents included in this record of proceedings were accurate copies of documents filed, tendered for filing, or entered in the respondent court. And certificate of filing of service. Pursuant to the Rule 2D, the Indiana Rules of Procedure for original action, the foregoing was electronically filed by IEFS on November 6, 2023, was served upon the following through IEFS and via electronic mail at the noted email addresses. So the judge, Scremin, Librado, McClelland, and Rokita, Indiana Attorney General. So, yeah. All sorts of stuff going on behind the scenes, guys. Let's just hope that they get justice. You know, this is just, it's mortifying. It's why I'm working on it pretty much daily. Things are coming in daily. There's been lots of paperwork. There's also that other 200-page volume 2 that I need to take a look at, and we might go through that later. I want this to work out for the families. I want everything. If they gotta scratch it, scratch it. I don't know how they're gonna be able to actually get this case. I can't see it working. I can't see how they're gonna go without having a kabillion different things that they can challenge. I mean, the judge is questionable. The I'm sorry, I always liked McClelland, but he's a little iffy on me right now. I don't quite know what I'm thinking about any of this. That's all we want. That's all that we want is justice for these little girls. You know, it's hurtful to know that these families are going to continue suffering. So, guys, with that said, I'm going to thank you very much for hanging out with me. We went through quite a bit. It takes time, doesn't it, going through the documents? So, I'm going to take a look at the other one that was put out, volume 2, like I was saying. And if I think we need to go through that, that's exactly what we're going to do. So, friends, thank you once again. I appreciate you. If you haven't subscribed, please do. Don't forget to hit that like button, and I'll see you in the next one, guys. Bye.